Hi, I'm Carol Birch, and I'm here today to talk to you about legal and financial essentials for caregiving. Caregivers have a lot on their plate, and one thing that I'd like to help you take off your plate is getting ready legally and being able to take care of things legally for your care recipient. So the thing that we're going to talk about legally is powers of attorney. What are powers of attorney? That's just a piece of paper that lets the principal, that's the person who gives the power of attorney, lets the principal give permission to an agent or attorney in fact to act for the principal. So the financial power of attorney, or the power of attorney that lets you handle everything except healthcare matters, is called a statutory durable power of attorney in Texas, or it could be called a general durable power of attorney, or just a general power of attorney. The medical power of attorney is the document that lets you give permission to someone to handle medical issues. The medical power of attorney is effective only upon incapacity of the principal, but the financial power of attorney can be effective as soon as the principal signs it. The medical power of attorney is very important for the, not just for the paper, not just for signing the piece of paper, but for having the conversation with your loved ones about what your values are and what is important to you if you become incapacitated. The person who you appoint as your agent needs to know what your wishes are regarding quality of life. They need to know what you value most between staying alert enough to interact with loved ones or having enough medication to alleviate pain, for example, or how you weigh the choice between longevity versus being perhaps a financial burden on the family, and whether and when to agree to a feeding tube. So as caregiver, you want to have a conversation with your care recipient about all these questions and find out what their wishes are so that if they become incapacitated down the road, you'll know what decisions to make. Because as the agent under a medical power of attorney, your job is to make the decisions that the principal would have made if she could have, if she were not incapacitated. So, for example, you want to think about, what does the care recipient fear most? For example, is it being in pain or losing the ability to think? Or is it being a financial burden on loved ones? All these questions are important for the conversation that sets up you as the caregiver being the agent for your care recipient. As I said, the medical power of attorney is not about the document. It's about the conversation. And it's not just a conversation with the medical agent. It's a conversation with all the loved ones so that the loved ones who are not medical agent are on the same page. So maybe the medical agent and the care recipient have had conversations and the medical agent knows what the care recipient wants, but the other family members don't. And then they could accuse the medical agent, oh, you're not doing what mom wanted, even though the medical agent is. So we've got to have that conversation loud and clear with everybody. We can't just have it with the medical agent. That's unfortunate because some people are very private and they don't want to announce their values to all and sundry. Nonetheless, it's going to make it easier for the medical agent down the road if the whole family knows what the care recipient's wishes are. Just some details about the document. The medical power of attorney form is in the Texas Health and Safety Code. And here in Texas, we are one of the few states that require the medical power of attorney to be in substantially this form. We don't allow non-compliant medical powers of attorney in Texas. So maybe you've seen 5 wishes, or you've seen a medical power of attorney form from another state. That is not sufficient. You need the medical power of attorney form from this state, unless your care recipient is already incapacitated. If the medical power of attorney is from another state and was validly executed in that state, it will be honored here in Texas, but ideally, you're going to use the Texas medical power of attorney form. Just so you know, it can be revoked even if the principal is incapacitated. So the principal can say, I revoke this power of attorney, even if they've got dementia and really don't understand what that means. And as I said before, the medical power of attorney becomes effective only when the principal is incapacitated. Now, what if we don't have a power of attorney form? Well, the Consent to Medical Treatment Act says that if your care recipient is in a nursing home or a hospital, we can turn to family to make medical decisions. So first we turn to the spouse, then the adult child with the consent of all the other adult children, a majority of the reasonably available adult children, then the parents, and then others. So we do have an option if the person is in the hospital or a nursing home. But if the person is at home, we need that medical power of attorney so that someone can make medical decisions for the care recipient. Now, as I said, the medical power of attorney is about the conversation, not the document. The financial power of attorney, on the other hand, is all about the document. First, we want that document to be durable. Durable means that it's effective even during the incapacity of the principal. We are doing our financial power of attorney in this case so that if the principal becomes incapacitated, someone will have authority to act, to pay bills, to get things done. So we want it to endure through the principal's incapacity. That's very important. It needs to be a durable financial power of attorney. We want it to be an immediate power of attorney, not a springing power of attorney. That means that we want it to be effective immediately upon signing by the principal. Now, the care recipient may say, well, I'm fine right now. I don't want to give power of attorney to you. Remember that giving a power of attorney doesn't take away any of the principal's rights. What it does is give someone else permission to act as well. We want it to be immediate rather than springing into effect only upon incapacity, because sometimes it's very difficult to get a doctor's letter that says that a person is incapacitated. Sometimes doctors don't want to do that. Sometimes the principal hasn't been to a doctor in a long time and refuses to go. So we don't have a doctor's examination that would help us determine incapacity. We want to make it easy as possible on the agent, and in making it as easy as possible means making that power of attorney effective immediately upon signing. We want that power of attorney to include gifting and self-dealing provisions. Now, this is very important. The power of attorney is a very broad, powerful document, and we don't want to give our agent authority under it unless we completely trust that agent, unless we have looked at that agent through clear eyes and realistically assessed, is this person totally, scrupulously trustworthy. And if the person is not, then that is not the person we want to appoint as our agent. If we include gifting and self-dealing provisions, which are helpful so that we can do planning for Medicaid eligibility down the road, if we include that and the person is not trustworthy and acts unscrupulously, we have dug ourselves a hole. So very important for the care recipient to choose only the most trustworthy and honest agent. The drawback of the power of attorney for finances is, as Adult Protective Services calls it, it's a license to steal. If you do not have a trustworthy agent, they can steal you blind. That person can steal you blind. And so we must, again, I'm emphasizing it over and over, we must make sure that we're choosing someone who is trustworthy. There's no oversight of that agent. There's nobody looking over their shoulder, making sure they're doing the right thing for the care recipient. So again, it must be a trustworthy person. Important issues for both the medical power of attorney and the financial power of attorney. You need a primary agent, an alternate agent, and even a second alternate agent, because we never know what's going to happen. We never know when our primary is going to get pancreatic cancer and die in 2 months. We've got to have an alternate named. We cannot do a power of attorney and not name alternates. It just doesn't make sense. And for caregivers, if you already have a power of attorney and your care recipient is your primary agent, you may want to do a new power of attorney because your care recipient may not be capable of serving as your agent if something happens to you. You have a massive stroke or something happens and you're not able to act. You need a primary agent who can step in. Co-agents are not desirable. I do not like to name 2 people as primary co-agents. It is an opportunity for conflict and for confusion. It makes it harder for the agents and it makes it more difficult with third parties. So they are not desirable. Remember that you must have mental capacity to give a power of attorney. So if your care recipient is already incapacitated, it is too late to get a power of attorney. You must have mental capacity. Now, what if you don't have capacity and there are no documents? Then we turn to guardianship. Guardianship is a legal proceeding in front of a judge where we say to the court, this person cannot act for herself and I should be appointed to act for her, to be her guardian. Guardianship is expensive. It's time consuming. It is not ideal. We want to avoid it if at all possible. Sometimes though, that's the only thing we can do. We have to do a guardianship. Now I want to switch gears a little and talk about paying for long-term care. When someone can no longer live independently, it's time for them to have assistance over the long term. We can pay for long-term care privately out of our own pocket. We can pay for it with long-term care insurance. Veterans who meet the eligibility requirements can pay for long-term care with the VA aid and attendance program. Or we can look to the Medicaid program to help pay for long-term care. And I'm going to talk a little bit more about the Medicaid eligibility requirements to let you know what you can expect if Medicaid is what you're going to need to look to. So Medicaid is what we call means tested. That means that you've got to have below a certain amount of income and below a certain amount of resources before you can qualify. You also have to meet something called medical necessity. Medical necessity is not simply, oh, I need to be in a nursing home. It is more than that. Medical necessity is most easily met by having dementia, not being able to self-medicate. But there are other ways to meet medical necessity as well. So just keep in mind that you don't want to take all the steps necessary to prepare someone financially for Medicaid and then find out that your care recipient doesn't meet medical necessity. You've got to bear in mind that that is another requirement for qualifying for Medicaid. But financially speaking, the Medicaid income cap for 2021 is $2,382 gross monthly income. But even though we have that income cap, do not be alarmed, because income is never an obstacle to nursing home Medicaid. And here's why. If your gross monthly income exceeds that amount, we simply have to jump through some extra hoops in order to qualify you. But if you're going into the nursing home and your income, the care recipient's income is, say, $3,500 a month, you know that's not enough to pay for a nursing home. A nursing home is going to be $5,000 or $6,000 a month. The income cap means that that person with income greater than $2,382 just has to jump through some extra hoops. I'm not going to go through those hoops right now because I don't want us to get into the weeds. Just know that you're still going to be able to qualify. However, there are no magic buttons, magic golden hoops that we can jump through for resources. For resources, we have to remember that a single person qualifying for Medicaid may have no more than $2,000 in countable resources. Now, it's important to know what's countable and not countable. One house with an equity interest up to $603,000 is not countable for Medicaid. If you're over 72 and taking your required minimum distributions on a traditional IRA, that traditional IRA is not countable for Medicaid purposes, okay? Other non-countable resources include one vehicle and prepaid burial plans. Countable resources are things like investment accounts, a rental property, that land out in Real County that your mom inherited from her grandfather. That's a countable resource. Now, when you have a married couple and the spouse is at home, in 2021, the spouse at home is allowed to keep up to $130,380. That doesn't mean that if they've got $130,000, the spouse is going to keep that. They keep 1/2 of the countable resources up to $130,000. So it starts with 1/2, and then the other half is allocated to the spouse at home, to the spouse who needs care. Okay. I know that that's just a cursory review of what the spouses are allowed to keep, but I don't want us to get into a lot of the details. The thing to remember is when you're looking at a couple and one spouse needs nursing home care, it can really pay to talk to an elder law attorney about Medicaid eligibility and how to maximize what the spouse at home is allowed to keep. Because many times we can increase what the spouse at home is allowed to keep. So that's very important to keep in mind. Another thing to keep in mind is that when you go on Medicaid, the state says, we're going to let you keep those exempt assets, such as the homestead. But upon your death, we want that homestead to be sold and then pay us back for what we spent on your care. This is called the Medicaid Estate Recovery Program, or MERP. There is no estate recovery if the Medicaid recipient's spouse is living at the time of the Medicaid recipient's death. There's no estate recovery if there's a child with a disability, or if an unmarried child resided in the home for the 12 months immediately preceding the Medicaid recipient's death. So there are ways to avoid estate recovery. There are other ways that I don't have in this slide, other exemptions and exceptions. Those are the main three. We can also avoid estate recovery with a ladybird deed or a revocable transfer on death deed. Both of those allow the homestead to pass outside of probate to the persons that the Medicaid recipient wants to receive their home at their death. Now, this is not a complete solution. For example, if you have a single person and they do a ladybird deed to their children, we still have an empty house sitting there while the person is in the nursing home. We may put somebody in the house, that would be a good option, but you want to consult an elder law attorney before you do that. You want to, but if you didn't put someone in the house, the children are going to be responsible for maintaining it, paying for its upkeep, its taxes, its insurance, because the Medicaid recipient who's in the nursing home doesn't have any money to do that. All of their income goes to pay the nursing home, and then Medicaid makes up the difference between what the nursing home costs and what the Medicaid recipient brings in. I know I've gone pretty quickly, however, we'll have time for questions, and I hope that this has been helpful to you.